What I set out to do with my doctoral research is to better understand what the challenges and opportunities are for a shift to ecological law by looking at current law with a focus on mining and looking at it from a lens of ecological law. So what I want to do today is first introduce this lens. Apologies to those of you in the workshop in Vermont, I don't know, 2 years ago or less or whatever, that already heard a little bit about this. Then I will go through 2 case studies and try to apply this lens of ecological law to the case studies, and only touching on them superficially, and it's also a very much a work in progress. Sorry. And finally, I will close with some brief reflections. So the lens of ecological law is a tool for identifying the major affinities and inconsistencies between existing laws and ecological law. It consists of 3 principles that I have drawn from the growing body of scholarship out there. So principally the work of Klaus Bosselman, Cormac Cullinan, and Jeff Garver, but many others as well. So the first principle is ecocentrism. So law that follows this principle recognizes and respects the value of all beings and the interconnectedness among them, equally promoting the interests of human and non-human members of the Earth community. And so this principle is really centered on the view and understanding of the human-Earth relationship that underlies the law. The second principle is ecological primacy. It calls for law to ensure that social and economic behavior and systems are ecologically bounded, respecting planetary boundaries. And it has a material focus, aiming really to constrain material and energy use within ecological limits, and to restore and maintain ecological integrity. Finally, under the principle of ecological justice, law would aim at ensuring equitable access to the Earth's sustaining capacity for present and future generations of humans and other life, as well as at avoiding inequitable allocation of environmental harms. This principle aims to translate respect for all beings into actual equitable access to sustenance and avoidance of harm. So it's obviously, the 3 are linked obviously together, but there's this difference of focus from the worldview to like really material impacts to justice. So these are very basic statements of the lens. There's quite a bit of detail behind each of these principles that I can't get into. And also my intention is not to say that these principles should govern ecological law. They are normative and they're stated as normative principles, but and they could be adopted, but what I want them for is to use them as a lens to critique existing law, to see how far are we from where more or less the scholarship says we want to be, or for where we want to go. So now the case studies. First, the mining ban in El Salvador. So El Salvador is the smallest and most densely populated country in Central America. I think I should slow down, sorry. 6.3 million people in about 21,000 square kilometers. It's also the second most deforested in the Americas after Haiti. There is a history of extraction, but mining operations came to a halt due first to low mineral prices and then the devastating civil war in 1980 that took about 75,000 lives. When the war ended in 1992, Latin America was seeing the widespread adoption of neoliberal policies, including measures to attract foreign investment. There was a boom in mining projects in Latin America, fueled by high mineral prices as well as new extraction technologies. And so in El Salvador, the mining law was reformed in '96, and mechanisms protecting foreign investment were adopted to attract mining companies. By the early 2000s, however, well, several companies had obtained exploration concessions, and at the same time, however, communities and civil society groups began opposing metal mining or mining projects as they experienced themselves the negative impacts of exploration, and also as they saw or learned from the negative experiences of other countries of neighbors, and as well, very much because of the serious water pollution and availability issues that the country was having to deal with. In 2005, a national roundtable against metallic mining was formed, and there was so much opposition to mining in the country that in 2006, the conservative government in power actually adopted a de facto moratorium on mining, and this was officially put in place as a moratorium in 2007. Then there was a period of violence and intimidation as people campaigned to stop mining. In 2009, actually, 4 anti-mining campaigners were murdered. But finally, on March 29th of this year, the country adopted a law prohibiting all surface and subsurface metal mining, the first of its kind. So before I go into the law, of course, elephant in the room, a prominent part of this struggle is the investor-state dispute that the Canadian company Pacific Rim brought against El Salvador. And I'm not going to get into it, it's just an important part of the history. But the great thing about this story, at least, is that last year El Salvador actually won this case. So they were awarded $8 million in costs, which of course have not been paid, and hardly compensate for the work and you know, the distraction of having to be fighting this case. But I think it also fueled the support for the ban in some ways. Anyway, so the recent law prohibiting, maybe we can go to the first slide. It really doesn't matter. It's more of the same. The recent law prohibiting metal mining is really short and to the point. It bans all metal mining activities as well as the use of toxic chemicals in metal mining. It canceled all previous licensing procedures and also prohibits government acts allowing or enabling metal mining. So they really covered all the, in a very short and sweet law, covered all the possibilities. The Ministry of Economy will close all mines, and with the Ministry of Environment and Natural Resources, it's supposed to coordinate the remediation of mining sites. And the ban also includes artisanal mining, giving these miners 2 years to transition, and supposedly they're going to be offered help for this transition. So this is a touchy part, but so the rationale for the law, essentially there are 3 aspects that are interesting. The justification for the law is that the duty of the state to protect health and the environment, both under domestic and international law. Then there's the risks to health and multiple threats to the environment associated with mining, in particular the fact that mining threatens water resources. And then there was, in 2011, a strategic environmental assessment of the metallic mining sector, which concluded that due to the conditions of vulnerability in El Salvador, effectively controlling the environmental and social risks and impacts of metal mining was not possible, and that this activity also, metal mining, could not really make a positive contribution to social and economic development of the country. So I think that's an incredibly important assessment. Okay, so this is the first law prohibiting metal mining. Is it part of a shift to ecological law? So next slide, please. Just a reminder of the principles. Maybe, I mean, not quite, if we're strict about our framework. But there are some encouraging signs, I think. If we look at the ban from the lens of ecological law, we can say that it partially resonates with the principle of ecological primacy. Fundamental, or primarily. It's certainly, so we see like recognition of ecological limits, in particular related to water. The ban effectively prioritizes water over gold. And this was to a great extent a result to listening to the science regarding water depletion and pollution, but also just the science of acid drainage and the cyanide use and those risks. Also the intention to restore areas affected by mining resonates with this principle, although there is no reference to ecological integrity for this restoration process. So there is some resonance with ecological primacy, but not with ecocentrism or ecological justice, really. There is nothing in the ban equally promoting the interests of human and non-human members of the Earth community. There isn't even recognition of interconnectedness with other beings. And on ecological justice, while the ban seeks to protect water and environmental harms resulting from mining, which presumably, you know, it's for current and future generations. It's again only for humans, right? It's not. There is no concern for interspecies equity in this ban. Okay, so now the next case study, very different world, the Ring of Fire, and yes, it is inspired by the Johnny Cash song, for those who know that. This is an area, the Ring of Fire is an area of about 5,000 square kilometers in the James Bay lowlands of Ontario. It lies within the traditional territories of 9 First Nations that form the Matawa Tribal Council. I hope I'm pronouncing that well. They are Ojibwe and Cree. The region is sparsely populated and way up there in terms of ecological integrity. It includes undeveloped boreal forest and the largest peatland in the world. So rich mineral deposits were discovered there in 2007 and 2008. At one point, its potential was compared to the tar sands, so imagine that one. There are now several hundred claims in the area, mining claims, but currently there is only one mining proposal, like one mine proposal. Now, just the prospecting and exploration have already involved substantial impacts, and this can be seen in these 2015 photos that the conservation group Wildlands League took and made public. So anyway, the government of Ontario is pushing hard for the development of the Ring of Fire. So as Michael said yesterday, the state is the biggest developer. The First Nations seem interested, but at the same time, they are demanding that their jurisdiction be recognized. And there is an ongoing community-based negotiation process focusing on land management, revenue sharing, and capacity building. So I think it's fair to say that whether and how mining will be done in the Ring of Fire really remains to be seen. Okay, so next slide. But we can at least think a little bit about if it's done under Ontario law. You know, what do those laws look like from the lens of ecological law? So the laws that apply, I'm not going to describe them, but they're all anthropocentric. Minerals in the environment are seen solely as resources for human use, of course, and the interests of other beings are not recognized. Recognition of interconnectedness is perhaps present in the biodiversity strategy of Ontario and in the Endangered Species Act, which do apply, but are not as central. So on the ecological primacy front, there are strict environmental protection requirements, but these are focused on minimizing and mitigating harm in a traditional environmental law sense. So there's no reference either to integrity, to ecological integrity or ecological limits, including for rehabilitation. Environmental assessment is voluntary for mining projects in Ontario. And significantly, there have been, recommendations for conducting a regional strategic environmental assessment of the far north, the whole area where this project is located, with the cumulative effect focus before any development, but they have not been heeded. And this would really be, I think, important, an important way to move towards bounding economic activity within ecological limits. So the free mining system, the free entry system, assumes that mining is the preferred use of the land. And so it's, by definition, conflicting with ecological limits and ecological primacy and ecological justice. It privileges also short-term gains of mining companies and their shareholders, so a few humans today, rather than equitably for present and future generations of humans and other beings. On the positive side, however, the law in Ontario now does provide that the far north prospecting and new mines can only be carried out or built in areas where community land use plans allow for mining. However, although the staking of the Ring of Fire was done before this requirement, the new mines would have to, like the mines themselves, would have to conform, and this is also part of the negotiations. So I think, who knows, perhaps, perhaps the negotiations with First Nations will lead to recognition of their jurisdiction, and that might mean, if not, that Ontario law is not applicable at all, that it's applicable along with Indigenous law, and we have, we don't really know what that would look like, but it's still, I think, a hopeful place for maybe a different way of doing mining. So just a very few thoughts to close. These, of course, just two cases that are a tiny snapshot of mining, which is very diverse and complex and changed and is very different from place to place. So other case studies I'd be interested in to look at are, for example, what the Ecuadorian and Bolivian rights of nature frameworks mean for mining, but I haven't gone there. I would say, to conclude, that these two cases do show that there are openings for ecological law, especially on the limits, on the ecological limits front, but that we're pretty far in terms of ecocentrism and interspecies justice, like the complete concept of ecological justice. And there are positive things. So prioritizing water over a profitable industry is a great step. Also allowing community land use planning to exclude areas from mining is very promising. But at the same time, I think the larger point is that a shift to a different paradigm shift requires a lot more. We need to fundamentally question the drivers of mining, why we mine, so profit, consumption, growth, so that we can transform, not just ban or mitigate mining, and so that mining can be, so that we can imagine mining that is based on needs, really, and when you were talking about the different way of imagining money, I mean, a decommodified, like mining for not for exchange use, but for use value, for the use, like the, okay, so I'll leave that at that. But also that is carried out within ecological limits, and that is mining that is consistent with ecological justice. And last slide, along these lines, I have already done like a very crazy thought experiment of what mining would look like if we took the Earth Charter seriously, and this is a shameless promotion of this piece, and I would love to hear your thoughts if you do read it. Thank you.
The concept of free mining is something unbelievable. We have that still in Quebec.
Yeah.
Very powerful.
Thank you. That was very interesting. Can I ask a question about the situation in Nicaragua, El Salvador, oh good, it's easier to say. The pressure points that got to that point, as an Australian, just the notion of banning any kind of mining makes me salivate. It's just unfathomable. So what were the pressure points that got them there? Like, is that enlightened government, community activism, all of the above?
Yeah, I think from what I've read about that aspect of the campaign, it was this combination of really groups putting out not just like really putting out the science of the impacts, sharing experiences from other places where mining had been very destructive to livelihoods, and I understand that really the situation of water stress and deforestation and dense population in El Salvador had a lot of a big role, but the feelings that still remain from the Civil War, where there was very like huge intervention from the U.S. and so foreign firms, foreign companies coming to do mining, or somehow, you know, so I think it's very complex, but
it's still really excellent.
But it was a conservative government that first took the step to that had been pushing for like working with Pacific Rim, for example, very closely to make this project possible.
Because like other countries like ours, we've been whacking our members over the head with science. It doesn't matter. The political, you know, corruption aspect, the narcissism, and then.
Yeah, well, I think, you know, hitting the ecological limits was you know, seeing that close. I think was a big part of it.
One last question.
I've asked a few, so if there's anyone. I've been thinking a lot. By the way, I really loved that. I thought that was really interesting. I've been thinking lately about how environmental thinking is struggling to catch up to what the Anthropocene means, and the way a lot of environmental thinking can sort of reflexively refer to the Anthropocene and yet apply concepts that are more Holocene concepts, so applied to the past state, and including my own work. But I wonder if it still makes sense for us to talk about ecological integrity if we understand the Anthropocene. You know, the basic scientific research on the Anthropocene is sort of talking about this collapsing of humans and the Earth system, so that we're intimately impacting one another and our histories are combined. And so I'm not, in my own thinking, I'm not clear about ecological integrity, this nature that exists apart from humans, makes any sense if we understand the full implications of the Anthropocene. And Clive Hamilton's new book, which I guess has influenced my thinking on this, and I can share it with you, he's making this argument as well. And so when you
say again, sorry?
Clive Hamilton's
okay,
book,
right.
So when you're in your taxonomy, when you're talking about your second category, whereby you judge or evaluate the law with respect to ecological integrity, I wonder if that's applying a concept that belongs in the Holocene rather than the Anthropocene.
Oh, yeah, it's a great point. Jeff has made that point several times, different way as well. And I've tried to find an alternative concept that is sufficiently sort of recognized and succinct to substitute, and I don't think we have one yet. So the way I've dealt with this was just to define ecological integrity with that huge caveat, to say that it does not exclude. I used the definition of that it does not exclude humans. So I used the definition of the Canada Parks Act that says that it's the sort of, I can't say it off the top of my head, but it includes the sort of the plant and animal components and integrity of the ecosystem, and so I just really see it as the animal components include us. We're no more, yes, the Anthropocene has changed things, but we're still an animal component of the ecosystem. You know, an animal gone out of control, perhaps, but it's a very, very good point. And, you know, absent a fully graspable alternative, because mutually supporting human-earth relationship, I think, is not well recognized enough out there. There's so much discussion, like the integrity, as Klaus Wasselman argued to begin the conference. The integrity concept is better, just better recognized at this point and defined. So it's, but yeah, it's a tough one.
Sure.
But
Can I just add to that conversation, the stuff that, okay.
I'll just give a chance to Peter to speak.
Okay, so just quick. So yeah, one of the background assumptions of the E4A project is in discourse and direct collapse. But across all of these frameworks at once, so it's a much broader version of what Peter just said. So it makes the whole task of coming up with the right language, new language, or new metaphors much more difficult. So it's not just building on that point. Thank you for it.
I just want to say that at the local level, but no, I think it's important, if I could. I don't think, sometimes we're at the grassroots level, the language isn't as important as there used to be a forest there. We'd like to have it back again. You know, like there are ways of quantifying what's been lost and what we want, scenario planning stuff. So I just, you know, there are ways to get around this without getting too spun out about permission to use certain language. So.